Currently, Malaysia has no legislation that oversees matters of private hospital medical professionals' duty of care. Hence, Section 3 of the Civil Law Act 1956 will be applied in this legal analysis, as it states that where no statutes have been enacted on the matter, English law shall come into place to fill in the blanks of Malaysia's legal system. The core legal issue to be explored, therefore, is whether the resident medical officer, RMO for short, and the consultant cardiologist, CC for short, owed Marjorie a common law duty of care arising from a doctor-patient relationship. To establish negligence, three key elements must be proven: a duty of care, a breach of that duty of care, and causation. Medical negligence differentiates from ordinary negligence by emphasization of doctor-patient relationship. The first element is duty of care. A duty of care in medical negligence cases arises when a professional undertakes the responsibility of providing diagnosis, advice, or treatment. This is well established in the case of R.N. Bateman and further affirmed in Gao Nanseng and Nagama and others. In this situation, Marjorie presented to the private hospital's emergency department at 10 p.m. with chest pain and shortness of breath, classic warning signs of an underlying cardiac event. The RMO initially diagnosed her with angina and ordered an ECG to confirm the diagnosis. The CC was then consulted and reviewed the ECG, concluded that Marjorie had not suffered an acute myocardial infarction. Tragically, Marjorie suffered a major heart attack the following morning and passed away. Although there may have not been a direct communication between the CC and Marjorie, this does not negate the existence of a duty of care. In Barnard and Chelsea and Kensington Hospital, the court held that a duty of care existed even when the doctor never personally examined the patient, as they have assumed responsibility through the advice and decisions made. Similarly, the cardiologist in this case interpreted Marjorie's ECG and made a diagnosis decision, thereby establishing a duty of care. The second element is the breach of that duty of care. The applicable legal standard is the Boehlem's test, laid out in Boehlem and Frian Hospital Management Committee. According to this test, a doctor is not negligent if they acted in accordance with a practice accepted as proper by a responsible body of medical professionals skilled in that area. However, Bolitho and City and Hackney Health Authority further refined this test by adding another limit, that the body of opinion must also withstand logical analysis. In Bolitho, the court emphasized that simply having expert support is not enough. The opinion must be reasonable and defensible. As such, the court may reject a professional practice if it does not survive judicial scrutiny as being logical. Furthermore, in Muller and King's College Hospital NHS Trust, Justice Kerr noted that the original scope of Boehlem applied more naturally to treatment decisions and may not be as easily defended in pure diagnosis cases like this one. The misreading of an ECG by a consultant cardiologist falls squarely within the realm of diagnosis. Given the CC's senior position and expertise, there is a strong argument that he failed to meet the standard of a reasonably competent cardiologist. The failure to recognize or act upon indications of possible heart attack in the ECG in a patient presenting with classic cardiac symptoms is likely to be considered a clear breach of the expected standard. A cardiologist is expected to possess the skills to accurately interpret ECGs, a basic but critical function of their role. Therefore, the consultant's conduct would likely fail both limbs of Bolitho and Boehlem tests, as no responsible body of opinion would defend a misreading that leads to fatal consequences, nor could such an error be viewed as logical or reasonable. Finally, the third element is causation, which must be established both factually and legally. The traditional test for factual causation is the but-for test, as seen in Barnett. In that case, although there was a breach, the patient would have died even with treatment, so the claim failed. However, Marjorie's situation differs significantly. Had she received the correct diagnosis and appropriate care overnight, including potential monitoring, medication, or even emergency treatment, there was a real and substantial chance that the outcome would have been different. In Bailey and Ministry of Defence, the Court of Appeal recognized that where medical negligence is one of the multiple causes, it is sufficient to show that the negligence materially contributed to the harm. The claimant in the case suffered brain damage due to a combination of negligent and non-negligent causes, and the court held the hospital liable. By applying the material contribution test to Marjorie's situation, even if there were other contributing health factors, the CC's failure to act materially contributed to her deprivation in receiving treatment, thus leading to her death. Moreover, Wright and Cambridge Medical Group supports the proposition that an initial negligent failure to refer a patient can be actionable, even if subsequent treatment was also negligent. The court found that the GP's delay in referral caused a critical window for treatment to be missed. The parallels with Marjorie's case are strong. Both the RMO and the CC missed opportunities to escalate care, and the result was fatal. Further support can also be drawn from Chester and Afshar, where the surgeon failed to warn the patient of a small risk that later materialized. Even though the risk was inherent to the procedure and may have occurred anyway, causation was found because the breach deprived the patient of the opportunity to make an informed choice. Similarly, Marjorie was deprived of the opportunity to receive potential life-saving care. The failure to act on the warning sign and misinterpretation of the ECG removed any chance of appropriate medical intervention, and the RMO's lack of act to inform Marjorie about any possible cause and complications of angina also deprived her from deciding to pursue further investigation or care for the issue. In conclusion, all three elements of medical negligence are likely present. A clear duty of care arose from the clinical involvement of both the RMO and the CC. That duty was later breached through misdiagnosis and failure to act on clinical signs, which fell below the standard expected of reasonably competent medical practitioners. Finally, the breach directly caused Marjorie's death, or at the very least materially contributed to it, and deprived her of the opportunity of life-saving treatment. In this case, it is highly likely that both the RMO and the CC had owed and breached Marjorie a duty of care. Marjorie's family would have valid grounds to sue for medical negligence. Under Section 6 Sub 1 of the Limitation Act 1953, the time limit for pursuing an action of tort is 6 years, which Marjorie's family would be well within that period to initiate legal proceedings.
The second question is to analyze whether the private hospital may be held liable for both the resident medical officer and the consultant cardiologist. Now, the fundamental issue is whether the private hospital may be held liable for the negligent actions of the resident medical officer, who is an employee, and the consultant cardiologist, who is an independent contractor. Now, an employee is under a contract of service governed by the Employment Act 1955 and Industrial Relations Act 1967, whereas an independent contractor is under a contract for services governed primarily by the Contract Act 1950 and the terms of the specific contract. The liability of the private hospital depends on the tortfeasor's legal status and is determined by two separate doctrines. Firstly, vicarious liability, where the employer, the hospital, is held vicariously liable for the torts of its employee, the RMO, provided the tort was committed in the course of the employment. While traditionally vicarious liability required a master-servant relationship, the courts have evolved the test for highly skilled professionals. The federal court adopted a multi-factor approach, evolving it into a relationship akin to employment test to evaluate the entire working relations and determine the true status of the tortfeasor. This case was confirmed in the case of Dr. Kok Chong Seng and another, where it was said that the court must use its evaluative judgment by considering multiple factors in addition to control. The goal is to ensure that a defendant like a private hospital cannot avoid vicarious liability simply based on technical arguments about the employment status of the negligent individual. It essentially answers the question, does the relationship look enough like an employment relationship that it would be fair and just to hold the hospital responsible for the employee's fault? The second doctrine is the non-delegable duty of care, where primary duty is imposed personally on the hospital, meaning it cannot escape liability by delegating the duty to a third party, an independent contractor. The doctrine represents a significant shift in how Malaysian law approaches hospital liability in healthcare settings. The landmark authority to this principle is the Seo Chin Yi case, where the court established that a private hospital owes an NND to its patients primarily derived from the hospital's duties under the Private Healthcare Facilities and Services Act 1998. And the 5 criteria for NND, which is adhesion relationship, vulnerability, lack of patient control, delegation of integral function, and negligence of the delegate. Now, regardless of the outcome of the akin to employment test, the Seo Chin Yi case imposes a primary non-delegable duty on the private hospital. Now, applying the principles to the situation given, the RMO misdiagnosed Marjorie with angina when she was in fact experiencing symptoms of an acute cardiac event. that led to her death. This is a clear situation of negligent diagnosis. The RMO was performing a core integral function of the hospital's emergency services, which is the initial assessment and diagnosis of a patient presenting in the emergency department. This act was indisputably committed in the course of the employment. As such, the private hospital will be held vicariously liable for the RMO's negligent diagnosis. Next, the consultant cardiologist misread the ECG and concluded Marjorie had no acute myocardial infarction. Misreading a core diagnostic test is a clear negligent act related to diagnosis by a specialist. There are two pathways for liability. Firstly, by using the relationship akin to employment test, where the court could assess if the consultant cardiologist was so integrated into the hospital, the relationship was akin to employment. Since the consultant cardiologist's expert services, which is reading the ECG to confirm a serious heart condition, are essential to the hospital's ability to provide specialist care, and the hospital facilitates this consultation. There is a strong argument that this relationship meets the integration criterion of the multiple tests. As such, the hospital is likely to be held vicariously liable based on the relationship being akin to employment. Secondly, by applying the non-delegable duty from the Seo Chin-yi case, where Marjorie presented to the hospital and entrusted her care to it. The hospital accepted the patient and had a primary NDD to ensure she received competent cardiac care. By having the consultant cardiologist read the ECG, the hospital delegated an integral and critical function of its duty of care. When the consultant cardiologist negligently misread the ECG, the hospital breached its own NDD. As such, the private hospital is primarily and directly liable for the consultant cardiologist's negligence because it breached its own personal NDD to Marjorie. Now, in summary, liability for the RMO, the hospital is held vicariously liable because the negligent misdiagnosis was an act committed in the course of employment, while the relationship between the consultant cardiologist and the hospital will likely satisfy the relationship akin to employment test. The more conclusive and direct route to liability is provided by the non-delegable duty, which renders the independent contractor defense unsustainable. Thus, the hospital is held primarily and directly liable. The second part to the second question is how does the recent decision of Seo Chin-yi versus Columbia Asia Sindriambra 2024 affect this difference? Now, in this case, Mr. Seo was rushed to Columbia Asia Hospital's emergency department due to a severe post-tonsillitis comed bleeding. While under the hospital's care, a consultant anesthetist, an independent contractor, was negligent by causing a critical delay in securing his airway during emergency procedures. This negligence resulted in massive cerebral hypoxia, leaving Mr. Seo with permanent brain damage and severe disability. Now, the High Court dismissed the claim against the hospital, finding that the doctors were independent contractors and thus the hospital was not vicariously liable. It only found the consultant anesthetist liable. Again, the Court of Appeal upheld the dismissal against the hospital. However, the federal court overturned the dismissal against the hospital by a 4-1 majority. The federal court ruled that Columbia Asia Hospital was jointly and severely liable for the patient's injuries, specifically holding that the hospital's defense that the consultant anesthetist was an independent contractor was not sustainable in law, and that the private hospital owed a statutory NND to Mr. Seo, a duty that was personal to the hospital and could not be passed off to the individual doctor. Critically, the federal court did not rely solely on common law principle. It strongly anchored the NDD in PHFSA 1998, where its regulations are intended for private hospitals to remain personally responsible for the treatment and care of patients, regardless of whom they employ or engage for the task. This legislative intent makes the private hospital a provider of care itself, not just a landlord providing premises.
Further, the federal court emphasized that patients seeking treatment should never have to concern themselves with issues of responsibility and separate accountability. The non-delegable duty of care ensures that the solvent entity, the hospital, is the one that must answer for the failure of its service delivery system. This case significantly impacted the distinction between employee and independent contractor liability by providing a highly effective alternative route to holding a private hospital liable. While vicarious liability remains the standard for an employee, the case makes the akin to employment test for independent contractors largely redundant because it introduced the non-delegable duty of care. This non-delegable duty is conclusively imposed on the private hospital, making it primarily liable for an independent contractor's negligence, thereby rendering the hospital's contract for services defense ineffective against the patients. The practical consequences of the non-delegable duty of care framework is that now private hospitals must maintain strict clinical governance and oversight over all practitioners, whether salaried staff or visiting specialists. Their exposure is higher, which necessitates stringent credentials and monitoring of all consultant cardiologists granted practicing privileges. Moreover, critics such as the Association of Private Hospitals Malaysia have publicly expressed that the ruling will increase healthcare costs due to the heightened risk exposure for the hospitals to pay higher indemnity insurance premiums, and which are then passed to patients, and it encourages defensive medicine where hospitals may order unnecessary tests purely to create a legal defense which burdens the system and patients. Further, Dato Sabaria binti Muhammad Yusof, who issues the dissenting judgment in this case, cautioned against the courts engaging in judicial legislation by expanding the area of non-tortfeasors liability like hospital through a policy-based doctrine, suggesting that such broad policy changes are better left to Parliament. In summary, the fellow court's decision in Siu Ching Yi fundamentally affects the distinction between employee and independent contractor liability by establishing the non-delegable duty for private hospitals. By anchoring this non-delegable duty of care in the Private Healthcare Facilities and Service Act 1998, the court made the hospital primarily and directly liable for ensuring safe patient care regardless of the contractual status of the medical practitioner involved. This effectively makes the hospital's former defense that a consultant was an independent contractor unsustainable in law and renders the prior akin to employment test largely redundant. Moving on, the next question is, can the private hospital seek to be indemnified by the resident medical officer and the consultant cardiologist for liability? Once the private hospital is found liable to Marjorie's death, whether vicariously for its employee or directly under the doctrine of non-delegable duty, the next issue is concerned whether the hospital may seek indemnity from the resident medical officer, known as RMO, and the consultant cardiologist whose negligence caused the harm. Firstly, in relation to the RMO, who is an employee, the hospital's liability arises through vicarious liability, which is a form of strict secondary liability under the doctrine of respondeat superior. As explained by the Lord Millett in Lister v. Hesley Hall, vicarious liability is a species of strict liability and operates as a loss distribution device, ensuring that an employer who profits from the work of its employees bears the legal responsibility for negligence committed in the course of employment. Under common law, an employee owes the employer an implied contractual duty of care. If the RMO's negligence occurred in the course of employment, causing loss to the hospital in the form of damages paid to Marjorie's family, the hospital has an implied right of indemnity against the RMO as established in Lister. The hospital can in law recover the full amount it paid from the RMO, provided that RMO's conduct was not sanctioned by the hospital. However, despite this legal right, private hospitals rarely pursue indemnity against employees like the RMO for policy reasons. As noted in the dissenting judgments and subsequent commentary following the Lister's case, it is widely considered bad practice for employers to sue their employees for mere negligence, as it ruins industrial relations, discourages job applicants, and defeats the social purpose of vicarious liability. Secondly, regarding the consultant cardiologist, who is an independent contractor, the hospital's liability is primarily grounded in the non-delegable duty of care it owes to the patient, as affirmed in the landmark federal court decision in Siu Ching Yi v. Columbia Asia. The court in this case held that private hospitals owe a statutory and personal duty to ensure that reasonable care is taken in treating patients, regardless of whether the duty was performed by the employees or independent contractors. Nevertheless, the cardiologist remains a direct tortfeasor for his negligent misreading of the electrocardiogram. As reaffirmed in Chai Beng Hock v. Sabah Medical Center, while hospital cannot deny liability to patients by blaming independent consultants, they may subsequently claim contribution from the negligent doctors responsible for the harm. Moreover, although the hospital remains primarily liable to the patient, it may have a right of recovery or indemnity against the consultant cardiologist if the latter breaches professional or contractual duties. Such recovery rights on the express terms of the consultancy agreement, as private hospitals typically include indemnity clauses requiring consultants to compensate the hospital for losses arising from their negligence or malpractice. For instance, in Dr. Chandran versus Gun C. Joy, the federal court held that although the hospital had breached its non-delegable duty, the negligence of A&T consultant was obliged under the consultancy agreement to indemnify the hospital. However, enforcement of such clauses ultimately depends on proving the consultant's negligence and the existence of a valid contractual agreement. Thus, the private hospital in majority case, after being held liable under its non-delegable duty, may pursue a claim for indemnity or contribution against the consultant cardiologist. This may arise under Section 15 subsect 2 of the Civil Law Act 1956, which allows apportionment of liability between joint officers or pursuant to any indemnity clause in the consultant's agreement requiring reimbursement for negligence acts. In summary, while the hospital remains liable to Majori's family under both vicarious liability for the RMO and non-delegable duty for the consultant cardiologist, it retains the right to seek indemnity or contribution from both individuals depends on the circumstances. Critically, the landmark federal court decision in Siu Ching Yi does not extinguish the hospital's internal right to recover from the negligence practitioners. The hospital retains the legal right to seek indemnity from the RMO based on the implied duty of care owed by an employee to the employer, though this is rarely enforced in practice. For the consultant cardiologist and independent contractor, the hospital can seek either full indemnity via express contractual clauses in their consultancy agreement as affirmed in Dr. Chandran, or seek contribution under Section 15 sub 2 of the Civil Law Act 1956. Thus, Siu Ching Yi ensures that the patient holds the solvent hospital directly accountable while allowing the hospital to utilize its contractual and statutory rights to apportion the final financial loss internally among the negligent practitioners.
I'll move on with the third question. To begin with, hospital liability refers to legal responsibilities of hospital for the harm or injury suffered by a patient as a result of the negligent acts or omission committed by the employees or contractual doctors or through the systemic failures in its own management or policies. In Malaysia, such liability is shaped by statutory laws that govern both the medical profession and hospital operations. However, while both public and private hospitals are regulated by statutory frameworks, the nature and extent of their liability differs due to their distinct legal status and governing statutes. The principal statutory law governing both public and private hospital is the Medical Act 1971. This act provides a uniform regulatory framework for medical practitioners in Malaysia by setting the standards of the qualification, registration and professional conduct for all doctors across both sectors. However, it primarily focuses on the conduct and responsibility of individual medical practitioners rather than the hospital institutions themselves. This distinction is significant because the law treats public and private hospitals differently because they are governed by different statutory frameworks. Public hospitals being part of the government are subject to laws such as the Government Proceedings Act 1956 and the Public Authorities Protection Act 1948, which defines the scope and extent of government liability, whereas private hospitals are regulated by the Private Healthcare Facilities and Services Act 1998, which imposes statutory duties on their healthcare providers and license holder of the hospitals, holding them accountable to patients. For public hospitals, they are operated by the government and are under the purview of the Ministry of Health. The foundational framework governing their liability is established under the Government Proceedings Act 1956, which allows civil actions to be brought against the government for the wrongful acts done by its employed servants, including doctors and hospital staffs. This act's purpose was to lift the common law doctrine of the Crown or state immunity against suit, thereby creating the mechanism for vicarious liability against the government and its public hospitals. Under Section 5 of the Government Proceedings Act, the government shall be liable for any wrongful act done or neglect or default committed by any public hospital in the same manner and to the same extent as a private person is liable for the acts of their agents. This establishes vicarious liability of the government for negligence acts by the government employed medical officers. This can be seen in cases such as Thaqif Ashraf bin Khairunnizam against Government Malaysia, Dr. Stanley Isaacs and the Government of Malaysia 2019. Section 6 of the Government Proceedings Act limits this liability by requiring a claim against the government that can only be brought if it could also be brought against the officer personally. Beyond establishing who is liable, the law also imposes procedural limits. Section 2 of the Public Authorities Protection Act 1948, which incorporated the Limitation Act 1953, established a 36-month limitation period for civil suits against the government, contrasting with the 6-year periods that applied to private hospital per Section 6, Clause 1 of the Limitation Act 1953. For private hospitals, the regulatory framework is Private Healthcare Facilities and Services Act 1998, which established licensing requirements and statutory duties on private healthcare providers. Looking at the provisions, Section 3 and Section 4 of the Private Healthcare Facilities Services Act 1998 requires all private healthcare facilities to be licensed and registered before operation. This to ensure that facilities are within a specific standard and are consistent across all parts of the healthcare facilities. Section 31 and Section 32 of the Act further mandates that each healthcare facilities must be managed by a qualified person to ensure the facilities' compliance with statutory requirements and quality standards. However, the Act initially provided limited guidance on the extent of hospital liability for negligence acts of independent contractors. This statutory gap created uncertainty, allowing hospitals to deny liability by arguing that consultants were not their employees. Prior to judicial development, Malaysian law followed the English common law principle of vicarious liabilities, where an employer is liable only for its acts of its employees. However, courts gradually began to recognize that hospitals owe patients a non-delegable duty of care, meaning that cannot evade responsibility by delegating inherently risky duties to independent contractors. This principle, rooted in Root Assets County Council, was adopted in Malaysian case Dr. Kok Chung Seng, where the courts emphasize that such duties should only be imposed only when it's fair, just, and reasonable to do so. This also can be seen in the case of Dr. Hari Krishnan, 2018. However, a landmark federal court decision in Seoul Ching in Columbia, Asia, 2024, where the federal court established that private healthcare facilities owe a statutory non-delegable duty of care to their patients, making them liable for the negligence of their specialist consultants, even if they are independent contractors. It was held in the judgments that the provisions of the Private Healthcare Facilities and Services Act makes it clear as daylight that the legislative scheme intends private hospitals such as the respondent is responsible for the treatment and care of patients, regardless of whom they employ or delegated the task or responsibility. The federal court also affirmed that private hospitals owe patients non-delegable duty of care, making them liable for the negligence acts of independent consultants. Further, the legislative intent of the act was to regulate private hospitals as providers of care and services, not just landlord providing space. This intent is what makes the non-delegable duty statutory in nature. Therefore, hospitals must remain accountable entity for the quality of services delivered on their premises. It can also be seen in the Act that a regulatory framework for private healthcare facilities in Malaysia with the aim of ensuring safe and properly managed care for patients. Even though these provisions of the Act do not automatically impose direct liability for compensation, it establishes statutory duties that underpin hospital accountability. Hence, private hospitals' failure to meet these statutory obligations may be used as evidence to prove that a hospital breached its duty to a patient. The Private Healthcare Facilities and Services Regulations 2006 further sets out how hospitals need to operate. We have provisions that regulates how the law treats registered medical practitioners as part of the hospital systems per Regulation 11 Clause 4 and 13 Clause 1 on patients that are admitted in a private hospital. They must be placed under professional care or treatment and shall be provided with necessary explanations, instruction for pre and post procedures. Also, in the case of Dr. Chandran and Gan Si Jo, it was held that the second defendant had a positive statutory duty under Section 31 Clause 1D of the Private Healthcare Facilities and Services Act and Regulation 47 Clause 1 of the Regulations 2006 to obtain a valid consent, as the law specifically requires hospitals to ensure that consent forms are properly explained and obtained. This shows that both Statutes sets out how care must be delivered within its facilities and clearly establishes statutory duty imposed on them. To conclude, Malaysian statutory law treats public and private hospitals differently based on their institutional nature. Public hospitals as government entities are shielded by procedural and statutory protections, and their liability operates indirectly through the government, which bears responsibilities for the actions of staff in public hospitals. Private hospitals, on the other hand, are regulated by the Private Healthcare Facilities and Services Act, places clear legal duties on them, and as interpreted by the courts, make them directly responsible for the negligence of doctors working under their name.
That's all from us. These are the references, and thank you for watching.